Hi, Jim Ziegler, the Alpha Dog. And this is the Dawg Pound. Oh.
Jim, we still gotta find that walkout music for you, man. We really do.
I've got the all-star panel with the all-star panels. I mean, we've cornered some of the superstars of legal compliance. And I'm going to introduce everybody here in a second, starting with Patrick O'Brien, the used car guru. Hello, Patrick.
Hey, Jim, how are you doing? Always good to be back. Jennifer, good to see you. Max, good to see you. I'm excited to hear about Mr. Ganther. Jim, you always say great things about him. So this is going to be fun because, like you said, we have the layman and then we have the expert.
Okay, well,
oh boy, fireworks.
Both experts. We got the layman and the
which is which, Max.
Okay, let's get our terminology down here, Patrick. I don't want to say that neither one's an expert. Okay, one of the most brilliant women in the car business. You've heard me say that before. Actually, one of the most brilliant persons in the car business. My friend, Jennifer Briggs. Hi, Jennifer.
Hey, Jim. I am excited to, I think I'm going to learn a lot today. I am by no means an expert in compliance, but I am an expert in process and installation throughout the stores. And I've set up a lot of processes for these departments where it's so very important. So I'm interested to see what James and Max have to say about today's topic.
Well, I'm going to be questioning Max and Jim, and I'm going to put the format out there, and let's see what the answers are. And this is a great friend. I'm teaching a class at Northwood University for students, automotive management. And Jim Ganther was kind enough to come in and co-host one of the classes with me. Hello, Jim. How you doing?
Hello, Jim. I'm, like I said, another day above ground. I have no complaints.
One of the foremost attorneys in legal compliance in the entire auto industry. Jim, this is a real privilege having you on the show. And you've written a book. What's the book titled?
Well, the book is titled Compliance for Green Peas and Old Dogs That Think They Know It All. And it is intended to be the first of two books. The second is in production, which is going to be Compliance for Old Dogs and Green Peas Who Want to Continue Learning. And the point of the whole deal is compliances can be very, very complex. And you hear that nobody likes lawyers. Why? They always use big words when a small one will do. Suffice.
You know what's brown and black and looks good on an attorney? A Rottweiler.
What I try to do is take compliance out of legalese and make it understandable to the automotive community. What good is knowledge if it can't be transferred? And if you don't transfer knowledge, you can't change behavior. So that is my shtick. Is my head is deep in the world of automotive compliance, regulatory developments, case law, and I try to make it understandable to a seventh grader. And
well, thank you, Jim.
It can be useful. So that's what I do. By the way, to all of our listeners out there, if you hear something that sounds like vacuums right outside my office door, our janitorial staff asked if they could show up right now. And they're outside vacuuming. And my office door will open shortly. And I will turn around and tell them, please don't mop my floor. You know,
okay.
I hope the audio is not a problem. Back to you, Jim.
Okay. And now, direct from Moscow, Russia. I mean, the mad Russian himself, the man who has made a career out of fixing U.S. elections.
Right.
And actually, compliance layman expert. The guy has written a book. He's written 4 books, actually. And I mean, I can't say enough good things about my friend, Max Zenon. Hi, Guy.
Hey, Jim, thank you. Thank you for such a wonderful introduction. You know, I got to say, like Jennifer, I don't think I'm an expert in compliance, but I think I'm an expert in real world. you know, and there's a real world application for everything.
Yep.
You know, because I believe that the most compliant dealership is the one that's closed, right? So if you want to be open, right, you have to make adjustments, you know, because not everything is black and white in the world, you know. So I do my best to help dealers make money on one side through income development and F&I, and then at the same time to do it in a compliant manner. So I look at compliance as income preservation, whereas F&I would be income generation.
Well, preservation or risk mitigation, either way, right?
And me personally, I'm sort of a layman expert as well. I have spoken at 3 NADA conventions on F&I compliance. So we got three different viewpoints here. We got the attorney who is recognized worldwide as a compliance expert in automotive, and we have 2 laymen who have got some credentials. So let's see where we go with this thing. Jim Gannon, I'm going to start most of the questions with you. Go to Max, and then I'm going to turn them over to the panel. That's going to be a little different format than we've done in the past. So anyway, Jim, what is the most pressing legal issue facing car dealers today?
Well, the flavor of the month right now, I think, is going to be the revised and expanded safeguards rule.
We talked about that.
I see this as a very, very real and present danger to the dealership community. And I got to be very careful how I put that. Dealers should, and I believe most of them do, wish to protect their customers' data. I mean, if you don't, you're a moron and you should find some other line of work. But they don't necessarily know how to do it, and how to do it in a manner that matches a new standard that was just promulgated at the end of October, beginning of November. And the downside of doing it wrong is catastrophic. I know Jennifer is an expert in process. So, I mean, this conversation is going to wind up on your desk in very short order, Jennifer, because I don't sell cars, I don't sell F&I products, but I am cognizant that you have to have room to make money, you know, and you can't bog down the process to the point where you're not moving iron and you're not moving paper. The safeguards rule expansion is going to require a demonstrable process be put in place. And because of the administration that promulgated these changes, failure to meet them is extraordinarily risky for dealers. And I swear I'm going to take a breath and pass the baton very shortly, Jim.
Okay, let me ask you, let's dumb it down a bit. What is the safeguards rule? There are a lot of people listening that might not even know what you're talking about.
Safeguards rule was derived, the authorizing legislation was the Gramm-Leach-Bliley Act. From the Gramm-Leach-Bliley Act, we got the privacy rule, and we got the safeguards rule, and we got the red flags rule from the Fair and Accurate Credit Transactions Act, FACTA. In 2003, when the safeguards rule went into effect, it was 11, 12 pages long, and it said dealers need to have a reasonable process in place. They have to do a risk assessment. They have to identify threats to consumer data security. They have to create policies and procedures and physical, electronic, and procedural protections to safeguard that data, and they have to periodically audit and update. It was a very skinny regulation. And what was reasonable and what was affordable and what was practical was sort of left to the dealers to decide. What happened in October is that a new and improved safeguards rule came out that built upon everything that's been the law for the last 18 years. But they got very, very specific about what an adequate safeguards program must entail. So you could have an argument a year ago that we have an adequate safeguards program in place, even if it doesn't have two-factor authentication for access to our database.
And
But
don't you have to have an administrator for this program in the store?
You've always needed to have an administrator, a program administrator, and we call that person the compliance officer, because there are lots of programs that you have to supervise. So you have to have a program administrator, but the new requirement is that that person has to be properly qualified. This was a big.
Wait a second.
Okay, because not most stores don't have a compliance director. Not even a lot of groups don't have that. So what is the qualification for this person? I do. I've worked with some in the past, compliance directors, and helped build a lot of processes around it when I was at Feldman in the Detroit area. But most dealerships don't have that role, Jim. So what qualifications does this new update to or expansion on the safeguards rule require that these folks have? Because most stores, I think it's like their DMS administrator or their IT manager who is responsible for safeguarding these systems. So what types of qualifications are we now required to have for the staff?
Jennifer, you've identified the $64,000 question. Any DA period said, we can't make it a CISO or a CISO, certified information security officer. Those people cost hundreds of thousands of dollars. And it's unreasonable to expect a single point that's selling 80 new and used a month to have a $200,000 piece of overhead in that. So between the original proposed rule and the rule that was promulgated in late October, they took away that requirement. That's progress, but they didn't backfill it with a specific list of these are the qualifications. So what we have done, what my company has done, and we consult with ACE, Automotive Compliance Education, which is a certification service. So we have helped them develop a ACE certification for Certified Safeguards Specialist. And that will have a couple hours of training on the safeguards rule as it exists. These are the legal requirements. Here's the practical application. This is what you do about it. But the difference between this and any other certification that we are aware of is that it will meet a requirement that's in the new rule that whoever your program administrator is must be regularly updated on evolving changes and threats to computer data security. And so what we're creating is a monthly or quarterly video update that's continuous, that as new threats are identified, that will be pushed out to those who are certified so that they can meet the requirements we know are in the text of the new rule.
Max, do you know anybody that's certified?
When does this all actually take place? Because when do we have to have somebody in a store already certified or compliant with this? When do we have to make sure we're ready for this?
You have to have a program administrator designated and with some basic training that you have to have by May 23rd, 2003. So you
we got time.
The back one, yeah.
Go way back.
But nothing on this. So nothing on this newer stuff that you were talking about done.
So the newer stuff.
So if we
the
have
enhanced requirements. Let me answer Patrick's question directly. The enhanced requirements start 1 year from the official promulgation, the publication of the final rule, which hasn't happened yet. We expect it to happen by the end of this month. So essentially, you will have a year to designate and train up this enhanced person. But if you don't have anybody right now, you're 18 years too late. You need to designate somebody today.
Right.
No,
And
no,
you
Jim. Most dealers are gonna get all over this sometime probably around April 2003.
Exactly. And we've seen I've not only have I watched this movie before, Jim, I was in it. 18 years ago, nobody paid attention to the safeguards rule, which we knew was coming for a year, and nobody paid attention to it till after it was effective, and then it was a fustercluck. And it's going to happen again. Smart dealers will be ahead of the game. Dealers who are less concerned about it will panic after the deadline has passed. That's generally
now, let me ask Max Zenon. Max, what do you? How many compliance officers do you know?
So whenever I do an audit, right, and I agree with Jim, these people needed to wake up 18 years ago. And unfortunately, a lot of them never did. So whenever I do an audit, and I'm going to make this as a blanket statement, 99.9% of dealers do not have a compliance officer. 99.9% of dealers never even thought they need to have a compliance officer. It's all news to them, right? And, unfortunately, now I feel that a lot of dealers, if not most dealers, have a target on their back, right? Because federal government and state government knows about the exorbitant profits that they're making, right? And if they need to go and find a dealership, this is the time to do it, when net profits are absolutely astronomical, right? So like Jim said, I'd like to encourage dealers and appoint a compliance officer, understand the basic duties and responsibilities of a compliance officer, so they can conduct an audit, they conduct some internal training, they understand what it means to safeguard non-public information, right? And I'm going to break it down in layman's language. Non-public information is information that cannot be found in the phone book. That is it. So I'll give you a perfect example. I was doing an audit last week in a car dealership where the finance director's office did not even have a door.
What?
Okay, guys, I'm not talking about the fact that there was no lock or there was no door. It's an open office. There were tons of deal folders there.
Driver's licenses everywhere.
I found two
credit bureaus
with titles. I found a box of in-transit plates, sent from DMV. So this is basic safeguarding of non-public information. And now we're going to get into this rocket science of safeguarding the same information electronically.
See, but I think we have, even though we don't have compliance directors in a lot of stores, I actually think the responsibilities we're talking about today are divided, because that electronic data security is not the finance manager's responsibility. That falls on other places. And I remember back when I was running the accounting offices, we would have those audits. I can remember Cadillac sent someone in to audit even our box to make sure. Now, for you young folks on the show, server boxes used to be a thing. So it wasn't even online systems. We physically had the boxes in the dealership. And I remember the OEM coming in to audit us to make sure we were secure enough. My finance managers knew nothing about that. That fell on my team as administrators. But I think it's two totally different things. When I was at Feldman, our compliance director did the audits like Max is talking about, his company does. And I can remember she would come in early because during construction, we shared an office. So I learned a little bit just from being in her general vicinity for like 6 months.
Was that
she would start her day.
JC? Was that JC?
JC, yeah. JC and I, we go way back. She was at my wedding a couple of weeks ago.
You know them.
Oh yeah, we know JC, the applier of the whip.
Side note, actually, I texted her and was like, "Hey, you should probably like jump on and do some comments here."
Yeah, this
we're
guy
talking
knows
about.
you.
Yeah.
Now, let me ask a question here. Now we're talking about the compliance. Now on July 9th, President Biden signed a directive that the CFPB, the Consumer Finance Protection Bureau, Financial Protection Bureau, that the and this reversed Trump. He said we're going to aggressively audit dealers. We're going to aggressively do compliance. We're going to aggressively go after the car dealers and other types of lending institutions. So this totally reversed Trump, who totally reversed Obama. So Obama said we're going to go after the dealers. Trump said no, we're going to loosen up on that. And then all of a sudden Biden said no, we're going back after them. So what is Jim, the question I have for Max and for Jim? I'm going to hit Jim first. Who's going to enforce this, and what's the penalties going to be?
First, a word about the Trump administration. They didn't have a policy of not going after dealers. They had a policy of only going after dealers if there was actual consumer harm. Thus, in the dealer-built case, as a quick example, they came down like a ton of bricks on dealer-built, and because dealer-built screwed up and thousands of consumers had their identities stolen. It just happened to be a safeguards case. So if you do wrong under Trump and consumers get hurt, you can expect to be hit and hit hard. The difference is under Biden, he will come after your dealership for technical violations, even in the absence of actual consumer harm. And that's what's so scary.
So how, in that, for instance, would they come after the dealer? What is going to be a trigger for that? Because in a consumer harm situation, we would assume the consumer is reporting to some type of agency. So where is the risk in this scenario where there doesn't have to be consumer harm? What is that trigger going to be for us?
Okay. The actual trigger, if you want to literally read it, there is something called the CFPB's examination manual. And it used to be 938 pages long. And currently it's over 1,700 pages long. It is nearly double. It is massive. And they have segments for how to audit a dealership. And they've got checklists. And if you read that, that is their playbook. And they're looking.
So Jim, it's called the CFPB?
Directed at car dealers?
Yes.
This section is actually, there's 1,700 pages.
Of the 1,700 pages, there's going to be 100 pages on how to examine a car dealership.
Okay, that's what I was asking.
And I don't see a threshold question of who was harmed. It's, do you do all of these things? And now, one of the things is the safeguards rule. And the new safeguards rule gives more bright line requirements, which if you don't do them, under Trump, the next question is, was anyone harmed? If not, slap them on the wrist, change it, go forth and sin no more. That fork in the road is no longer there under the current administration. If you didn't do this bright line requirement, we come after you. Even in
no matter whether harm is proved or not.
Wow. The whole guidance, if you recall, the CFPB's fascination with the APR that was paid by people who were assumed to be people of color or women.
Yeah.
Even though you never proved that the person was a minority or female, but if they paid more than someone else, that was actionable. Ask Ally Financial about that.
Let me say something, Jim. Let me say something a second.
The transaction was better, and that one.
Let me say one thing. I've been in F&I for years. I never discriminated against anybody. I laid everybody away.
That's
you
right.
wanted all of the money from everybody.
Yep.
Yeah.
And that's good.
No, and it's and on the other side of it, and this is something that I've always kind of been confused about is, they're coming after the dealers for that, right? Especially specifically on the APR side, we don't set the rates. You know what I mean?
That was going to be my question, and I'm going to go find
rate.
that.
The bank does. The customer qualified. The rate they get is what they qualify for. You know
No,
what I mean?
It's the dealer reserve. You've got flexibility.
Yeah,
but it's an initial brand. You
nobody.
Can't go over 200.
I'm sorry. I mean, with all the dealerships that we've all, you know, and the contacts connections we have in all the dealerships, I would be hard pressed to find even one person that goes, oh, because this person is, you know, a minority in some way or form, I'm going to abuse them more. I just don't buy that. I really
no. I've not seen it before, but I've seen
never had a case.
I'm going after everybody.
I never had a case ever.
Never.
I said, hey, this is a white guy. I'm going to give him a break.
Nope.
You don't give the white man discount. I never got the white man discount. People deny it exists.
But hang on, guys, because
I'm going after everyone.
Okay, we can say that, but the point of this is to educate the audience. And I don't know that I agree that I don't think an F&I manager is going to sit there and say that. But how do we protect ourselves? Because that's what this is about.
From the perception.
Exactly.
But if the bank sends back a different rate, and we have all seen it, and it happens based off of the name of the applicant, if it sounds ethnic, we've seen it. There's YouTube videos out there. There's all this. It does happen. How does a dealer protect themselves from the bank making a call based off of a perceived ethnicity?
Wow.
I don't think it's about the bank, right? The bank sends an approval, and it's up to the dealer to choose the markup, right?
But what I'm talking about, Max, is that, and related to this particular law, I have seen TV news where they send in the application and the bank sends all the same information, right? Income, job, time on job, address, everything is the same. The only thing that's different is the applicant's name.
But I think as the dealer, you have to worry about the 3 feet around you. You don't control the way the bank approves or not approves a deal.
No. But we have to protect ourselves, because if we're the ones that are going to be in
Jen,
line
give
for
me
this.
2 minutes and I'll explain it to you, please. So what you can do is control the markup, right? So
that wasn't my question.
If you want to be fair, right? There's a fair credit compliance program that was created by NADA that basically allows you as the dealer to choose maximum markup on every finance deal. And you have to present this maximum markup to every customer, regardless, you know, whether they're a minority or not. This fair credit compliance rule allows for deviations, right? Allowable deviations. For example, the customer couldn't afford the payment, or the customer had a better competitive offer. And that's why you had to reduce the rate to satisfy the customer. This is the part that the dealer is responsible for and can control. The way the bank approves deals is something completely outside of the dealership control.
So I understand that. My question is, in this 100 pages of this CFPD that says how to examine us, is there a specific way that we protect ourselves from us not being the ones violating it? And maybe this is what JC's comment is about here.
Well, you need to have paperwork in every deal, right? Stating that you presented this particular customer with your, let's say you decided as a business that you are going to utilize a 2-point markup on a 60-month financing. Mm-hmm. So in every deal, it should either be 2 points markup, regardless whether it's a white male or an African-American female, right? Or there has to be paperwork explaining why, in this particular case, this markup was less than 2 points.
Right. Well, and that part I know because JC actually, in configuring our presentation systems, even before the finance office, right, making sure our first pencil out is at that, regardless of who the customer is presented with that exact same rate, even if that was always our protection. Our first pencil went out the exact same way. That's why I said, listen, I've never sat in the box, but I can configure every form, every pencil, every contract that touches any piece of software. So I guess that was what I'm trying to get at.
Let me jump in here a second. I don't think anybody in the F&I part of the equation I'd never ever discriminated against anybody that was a person of color. I never gave an exception to a person for their whiteness. I mean, it never occurred to me. But so what Max is saying is the NADA suggests that you offer every customer the highest rate spread that the bank allows. And then you can negotiate down from there. Is that what you're saying, Max?
Well, you make a decision whether you're going to go for the maximum spread or not. But once that internal business decision is made, then you have to stick to it and present this markup to every customer.
Okay, that makes sense.
Point. Until you know the actual creditworthiness, the actual beacon score of the customer in front of you, your only defense is to present the same markup to everyone. And
that makes sense. That makes sense.
So my advice, for what it's worth, is just go with your tier 2, your captives tier 2 rate, and add a absolutely uniform, as Max put it. Got to be the same markup for everybody, and that's where you start your negotiations. You will, beyond that, you're going to have a policy of how tightly do you hold on to rate. Do you trade rate for product? There are reasons why that's a bad idea, but that's not today's topic. But start everybody the same way, and until you know their actual credit score, and then you know what the real rate is they're going to qualify. And at that point, you still have the same markup, and then it's subject to negotiation. The NADA approach is if you come off that uniform dealer participation rate by 1 basis point, you have to document why.
Okay.
There's another approach that is very, very similar to it, and that is instead of a standard dealer participation rate, you have a standard dealer participation range. And as long as you stay within the range, you don't have to document it. There's a lot more flexibility and a lot less paperwork with that second approach, but don't do either until you've talked to your local lawyer. And whatever your policy is, get it in writing and make for damn sure you actually do it.
Okay, Jim, now we're having a written policy for the dealership. You've got to have a compliance officer, an administrator. Now, this is all part of the overall umbrella that we're talking about today. Is that correct?
It's correct. If you want to have a compliance program, now we're talking much more broadly than just safeguards. I would say the safeguards rule is under the umbrella of the compliance officer, and you need to have one, even if you don't have a person who's an expert in all these things, and who would be. You just got to be responsible for making sure that those who are experts are doing their job. And that means that at least once a year, you audit these various silos. So, and you can't, like Jennifer, you may set up a great program, or your IT manager may set up a great safeguards program as far as the data in the server or the cloud goes. But you can't ask the person doing the work to audit his own work. So you have to have somebody independent, third party. Same thing with F&I deal jacket reviews, which you've got to be doing continuously through the year. You can do that in-house, or you can have somebody from your F&I product provider do it. But both in-house and product provider have an economic interest in the outcome of the transactions being reviewed. So at least annually, a third party who has no economic stake in the outcome has to come in and audit your computers.
A third party with no economic stake in the outcome. A third party, no economic. Jennifer, you might want to post that.
Yeah.
A third party.
Yeah, that's a good one.
Economic stake in the outcome. Jim Ganther, while she's putting that up, what is your phone number? How can I reach you?
You can reach me at the office at 813-221-2700.
Now, is that a should or a must?
Is that accurate, Jim, on the screen?
That is correct. That is my office number.
Okay, so I'm gonna leave it up for a second. So yeah, Greg Arroyo, who was my editor when I was writing for Auto Dealer Magazine and F&I Showroom, he said, I'll read this whole thing because it's pretty long, what he wrote. He says that this approach that we're talking about right now is exactly what the CFPB was trying to eliminate. Now, he's talking about Max's statement about presenting everybody the ultimate rate. We've got to understand we've got a very short period of time to figure out the best way to put together all the moving parts of a complex transaction for the consumer, and how we're going to be able to negotiate and have a deal the consumer can accept and is adequate for the dealership. And here's this interests me. And so we have to make quick judgments when we sort out the process. So when you pick the initial rate for negotiating a finance rate, we all know Asians are better negotiators. Boy, there's a.
I don't know that. That sounds like a racial thing.
Asians and
That's
Indians.
not true. That's not true.
Asians, Indians, and Arabs run. I mean, come on, that's a generality.
That is such a stereotype for people that don't know how to handle relationship or ethnical selling, man. Just you got to find common ground with them and just start talking to them. I mean, they're just like everybody else. It's such a dumb idea. I have hated that when people used to tell me that when I first started selling. I was like, okay, I'll take every single one that you don't want to handle because I'll do it. I'll take care of it.
Okay.
You know.
Well, I don't want to dwell on that, but the whole thing he said is that. Let's start out with this first sentence. Jim, he says this approach is exactly what the CFPB was trying to eliminate.
And I'm assuming I'm looking at this stream of comments. With Greg, if you're out there, were you referring to JC's comment immediately above you? There are many business decisions to make before quoting a person. A dealer should set their markup boundaries based on that location's demographic financial situation. I don't disagree with that. I'm saying that every dealership location has to have the exact same reserve, dealer markup rate or dealer markup range on every customer. And that, Jennifer's original question is, how do you defend the dealer? And the answer is you have to be able to demonstrate you had a policy that you followed to treat everyone absolutely equally out of the chute. And then things start going, every deal is different. And you're, again, under the Trump administration's policy, as long as people were treated fairly and there was no reported harm, you got a little bit more room to negotiate and structure and be creative. Under the current administration, which is a replay of the Biden administration, when it comes to this, consumer harm doesn't have to be proven. There is something that I refer to as the Franklin Toyota doctrine, and it should scare the snot out of every dealer within the sound of my voice. Franklin Toyota was investigated by the Federal Trade Commission, and it was demonstrated that they did not follow the safeguards rule. They were a security sieve. They were a screen door on a submarine, customer data at risk, customer data lost. And where it became scary is the Federal Trade Commission took the position that failure to follow the safeguards rule constituted consumer fraud, the F word, because every dealership gives every customer a promise in writing that we call the privacy notice. And the privacy notice says, buried in there, it says we have physical, electronic, and procedural safeguards in place to protect your data. That is a promise in writing that refers to the safeguards rule. And when
Let me interrupt you, Jim.
You violate a written promise to a customer, and it is consumer fraud. Katie, bar the door. That's the Franklin doctrine, and it's terrifying.
Jim, let me interrupt you a second. How does that apply when we give every Tom, Dick, and cars.com all of our data, and everybody in the world is in our computer extracting data, Cox companies, cars.com, car gurus, everybody's
because Jim, those are called service providers, and those service providers essentially mean third parties who have a need to access that data in the context of this transaction. So you can't have
this transaction.
this transaction. So banks obviously need to have access to data. Service contract companies have to have access to data. But if you sold or provided access to that data to Allstate so that they could solicit the customer for insurance, you would be violating the rule. But what you're describing, those are service providers. That's the exception. They're allowed to access the data that they need to do their job for this customer.
Well, Jim, do they actually? Now, see, I've always said that why does cars.com need to extract data after the deal was made?
Good question. And the data, I don't know what cars.com pulls, but if they pull data in the aggregate or specific to your deal that does not connect it to your name or other personally identifying information, it's fine.
There are several types of data being pulled. There's personally identifiable, transactional, and financial. Those are the three types of data. And I'm gonna say that I believe my opinion, the Cox companies pull all three of those after the transaction is done, and there is no need to know.
If that happens, it sounds to me like a gross violation of the safeguards rule. And
the dealer violated when he let those people in.
If the dealer lets them in, it's on the dealer, because the dealer is responsible for its service providers, and the service providers have to follow the safeguards rule. You're responsible for your service providers, and you're responsible for the access that you provide. So if you give that, and again, I don't sell cars, I don't do F&I, I have no idea what cars.com pulls.
Well, we're talking an if theoretical situation. If a provider did that, if a provider pulled 14 actionable fields after the deal was made, then the dealer is in violation.
Yeah, I can't defend the dealer giving away personally identifiable information to somebody who is not a defined service provider. That strikes me, without knowing anything more, that strikes me as being exactly what the safeguards rule is designed to prevent.
Well, and now I want to know what's the definition of service provider, because I think like there's a million different things, both after the transaction and before the transaction, where data is being accessed either through the DMS, the CRM, or in some circumstances directly through a script that takes the data off of the website. So, and I think not just from dealer standpoints, the selling of shopping behavior information is big money in our business. So at what is the definition of a service provider? Like I'm that crazy lady who pushed back and served an alternate NDA to Cox and Auto Trader some 10 years ago when I read the fine print of what I was allowing by doing business with them. So like, what is a service provider? Because we are just, whether we realize it or not as dealers, folks, I mean, we are passing this information around to Tom, Dick, and Harry, and then they're selling it to somebody else.
Service provider, in layman's terms, is a third party that has a need to know the information related to this customer and this deal.
And to this transaction.
For this transaction. So if you bought
not to remarket them down the line.
The service contract company is going to need to know some personal data, like the fact that you bought this car. What car did you buy? What's your APR? I mean, what did you pay for it? There's a lot of information that they are entitled to. Banks are the better example. Banks are obviously a service provider. They're providing a service, financing, and they're going to, they've got the electron microscope up your financials. So they are entitled to it. But somebody else who simply wants to know, what did you buy when, what's your credit score, so that I can sell that information to somebody who wants to target an ad to you, that is a problem. And it's a first instance a problem for the dealer. And another thing, did you know? Look, I turned 60 this month. I am a fossil. I know very little about computers. They are black. They use electricity. But my tech guy here at Mosaic Worldwide Headquarters, we were talking about data security yesterday, and he said, well, you're aware end-to-end, we're talking about end-to-end encryption of emails, as standard emails in transmission are encrypted. But if it's a Gmail account, Google sits over that and they have the key. And Google can read every single email you send through your Gmail account. And he tells me, and they sell that data.
I used to specifically target keywords for my competitors and their internet responses because it was cheaper to buy that than model keywords. So I would serve them with a Gmail ad based off of whatever keywords I knew because of, whatever I knew the competitors were saying over and over again in their crappy email templates. So Google would allow me to do that with keyword targeting to Gmail users.
Max, do you have any commentary at this point?
Jump in, Max. What happens in the real world?
So unfortunately, I think in the real world, most car dealers don't appreciate the value of data at all. And corporate America, and it's not just Cox, there's many other examples. These guys realize that data is probably more valuable than anything else. And they realized it 10, 15 years ago. And most dealers sign these dealer agreements, whether it's Auto Trader, Cars.com, whoever it is, without reading, without even letting their attorneys review these dealer agreements. Right. And that's the bottom line. And of course, these guys are going to take advantage of it and make money reselling the data.
They are reselling the data. That is 100%. An absolute fact.
Somebody to answer your question, why do they do it? The answer is very simple, because they can.
It's profitable.
Right.
Mm-hmm.
They can sell it over and over and over again. And that's the thing. I mean,
every dealer needs to read the EULA agreement on every one of their vendors, EULA, End User License Agreement, EULA. Everyone has a EULA agreement. And if you look at some of the vendors, I'm not saying Cox necessarily, I'm not sure they do or don't, but it says, we have the right to assimilate this data, to repurpose this data, to market this data, and to share it with our affiliate companies.
Which is everybody.
Right.
Which is everybody. Cox owns all these affiliate companies. Are they sharing your data with? Does dealer trader?
Yes.
Auto trader?
Yes.
Yes. They are.
100%.
Okay. Let's look at who has the financial data in the Cox organization. Max, where do you put the credit bureaus?
Dealer
Track.
Dealer Track.
Dealer Track. Okay. Does Dealer Track share information with Auto Trader, who shares information with their DMS program, which knows the transactional, the identifiable, and the
I don't think it flows that way.
Customer. Are they sharing that information amongst their subsidiary companies? And is that a violation, Jim Ganther?
Oh.
No pressure, Jim.
The share flow doesn't work that way, though. There is a share, but it doesn't normally work that way. It's not Dealer Track. Like Dealer Track is usually going to be at the end of it. The Dealer Track from the F&I standpoint. Now, Auto Trader 100% shares identifiable information about a consumer as they pass from Auto Trader's website to dealer.com's website. So the dealership, and I know because I have the product on some of my stores, right? Uh-huh. It's a behavioral targeting.
You are the financial, the computer whiz here of all the people in this broadcast.
Well, the data flows with Cox, but it doesn't flow from the dealer.
I'm asking a question. I don't know the answer.
Well, I mean, you could say like, if it like Jennifer, like you're saying, how does the data flow? Like you would be safe to assume that KBB and Auto Trader probably share a lot of the same data. You know what I mean? Because it's very much in the same segment. Whereas, like you said, with the DMS, the F&I side, it's probably
let's go back to the EULA agreement. Jim Ganther, I was talking about the EULA agreement on any vendor. End user license agreement. Is the dealer in violation of any of these laws if they're sharing information with a third party that does not? And you've answered the question already.
Well,
Yeah, here's the answer right there on the screen.
Here's this. When the customer first encounters Auto Trader, are they somehow giving consent to the sale of their data and creating a blanket exception to the safeguards rule? You know, when you click on an update or you see the legal notice, who actually reads the legal notices on a website or on an app? But customers do have the right. Okay, Jennifer does. Of course she does. She's Jennifer. But, you know, as
Jennifer reads every one of them.
When you get to be old as the alpha dog and me, you realize that you haven't got that much time left, and we don't want to waste it reading the fine print on a EULA.
But so at the very bottom of autotrader.com,
you treasure it more.
The very bottom, it says, by using this service, you accept the terms of our visitor agreement, privacy statement, and accessibility statement. So there are 3 separate links to the actual T&C. So it does have it on the page at the bottom where most consumers would never see.
Yeah.
And
read that again, Jennifer.
If you scroll all the way down on autotrader.com.
On the bottom of what? On the bottom of what?
On the bottom of the homepage of autotrader.com.
Okay.
It says, by using this service, you accept the terms of our visitor agreement, privacy statement, and accessibility statement. And each of those 3 are hyperlinks that link to a much larger T&C terms and conditions page.
Mm-hmm.
So it has it.
Incomprehensible.
The consumer gives up all their rights when they hit that statement.
As soon as they hit the page.
I mean, for all you know, you've agreed to be Bill Gates' towel boy.
Right.
It used to be by opening up breaking the seal on the CD that had the software. Break the seal, you've accepted the EULA. With all that,
Yeah.
there's a lot.
I don't know the answers. I'm just asking the questions.
If you're not
Listen, Jim, you know,
you are the product.
I gotta say, you know, if you look at it from perspective of all these service providers, you know, and if you can get away with it, of course you will, and of course they're getting the data, and of course they're selling it. And maybe I'm crazy, but I think recently, right, car gurus got caught selling leads to Carvana.
Yep.
I mean, that's all you need to know, guys. I mean, that's all you need to know. This is the real one.
All right. So now, real quick, Jim, Mr. Ganther, I had a question for you based on this. We've been seeing a lot of issues now that Max just brought up Carvana, so I wanted to bring this up, with them getting in trouble for not perfecting liens and titles at the right times. Okay, so I would love just to give from your side of it.
Carvana and titles, you're out there. I mean, okay.
I'd love to hear how from somebody who really knows this. How actually big of a deal is that for these guys?
They're selling them without a title.
They're selling them without a title.
That's the big issue.
It's
so. It wasn't what this show was about, but go there.
Here we are. When you get to things like people are driving around cars without a title and they think they own it. The issue of whether or not the financing has been perfected is, a UCC lien perfected. It's huge. If it happens once or twice, if you're doing 700,000 cars a year, you are going to screw up a measurable number of times. And if you rectify it as quickly as possible, kiss and make up, promise we're never going to do it again, adapt your policies and your processes to make sure it becomes less likely to recur, I'm not worried. When you don't give a rat's rip about it, and it happens a statistically significant number of times, at this point, as a plaintiff's lawyer, which I am not, I didn't have the ethical bypass, so I don't do plaintiff's law. But if I did, I would say, well, that is a RICO violation. And I'm into just civil RICO. I want treble damages. I want to disgorge all of your profits from every affected deal. And then I want to triple it. And then I want to add my generous attorney's fees. And I really don't know how you would defend against it, because when you are not perfecting and doing the lean work properly, you are committing consumer fraud. When you transmit the documents to a bank, you're committing wire fraud. And if the bank extends financing on the assumption that you're doing your end correctly, that is bank fraud.
It is bank.
And you could be prosecuted by the Department of Justice for that, and that would probably hurt your pride, but not your wallet. As bad as a class action civil RICO suit seeking treble damages, and the reputational damage is incalculable. Why do people do it? Goes back to Jim's original comment, because they can. And if you're not getting caught, eventually you assume you will never get caught. And a bad habit becomes a habit and you forget that it's bad. And when that happens, you're over.
That is the problem in most dealerships. You know, nobody woke up today and said, "Oh, today I think I'm going to jail. Today I'm going to get arrested, and today I'm going to be the bride of Big Bubba." You know, No, nobody woke up and said that this morning. Everybody that ever got caught always told me, "Well, that's the way we always did it. We never got caught. We never had a problem." And so
until they did.
That's the attitude these people have. When I say you can't do that, "Oh, we never got caught." Well, everybody in jail that was prosecuted on these things, they never got caught either until they got caught. What do you think, Jim?
Amen. Right now, there is, in the broadest sense, there's a consolidation in the retail automotive industry. We understand that the single point dealerships are getting swallowed up, and the larger dealerships are getting an ever increasing share of the total demo of car dealers. And how do you survive if you're a 1, 2, 3 point dealership? I think, this is just me, I don't sell cars, but I think that what you want to do is, take the soul approach, customers for life. See every customer who walks through the door not as a one-time transaction, but how do I create a relationship with this customer such that he will come back and he will recommend our dealership or me as a specific operator to friends and family. And that mindset, if you have that mindset that I want to take care of this person so that our relationship will continue and possibly continue through generations, that's the dealer that wants to do it right, because just hoping that I won't get caught this time, that fosters cutting of corners and general sloppiness. But if it's how can I treat this customer and every referral that comes through them literally like family in the best sense, then you create a juggernaut and you can survive as a 1, 2, 3 rooftop operation, because you're doing something that the consolidators really can't. You're playing a different game. They may be playing chess, but you're playing checkers. And there's always going to be a particular customer.
Jim, we're talking safeguards rule in the beginning.
Yeah,
we got off track. We got off track a couple times.
We got like 1 minute and 30 seconds.
Yeah, we started out with safeguards, and this has been an extremely interesting show to everybody. The panels learned things. Max learned things, believe it or not. So I appreciate you being here. This has been an incredible show. Jennifer, do you agree that this has been a hell of a good show?
It is, but I'm still looking for that translation for why, as a dealer, I should make an investment in this, in compliance of some standpoint. What am I going to lose or gain, I guess? Because so many of them don't have this in place, even though they're supposed to. And money talks. So how's that translation, Jim?
I'll answer that, because the dealers are going to have to get smacked a couple times by the federal government. And it's going to have to be some blood in the streets before dealers wake up. And I think Jim's going to say that I'm telling the truth. Max, am I telling the truth?
Right. Listen, money talks. And when somebody gets a $1.5 million fine, for example, like Honda of the Bronx, right, for
Deserve
violating every rule in the book, it sends a message. And I guarantee you that in a 50-mile radius of Honda of the Bronx, everybody knows about it.
Yeah.
That's it. I mean, I have never consciously discriminated against anyone of color. I mean, I've always had the same process, but the perception that you did that is just as damaging as if you really did it. And we've got to remove all perceptions of impropriety. Is that Jim?
Well, that is absolutely true. You want to eliminate even the appearance of evil, but Jennifer's point, it costs money. How much money per car? I don't know, but you know what? I'm in the Tampa Bay area, and the average dealer fee is probably right around $995. And in South Florida, it's significantly higher than that. And customers say, what the heck is this? If you viewed that $995 as being part of the pool of money that you have to spend because of all of these regulations and complying with them, I think it helps justify the dealer fee, but you need to budget compliance. You got to budget it like you budget your electric bill. And if it works out to being $100 a car, and it might, in fact, it probably does, bury that into your dealer fee because it's legit. This is part of the cost of doing business. And it's not because it's federal regulation that I've got to obey. It's because it is, in fact, the right thing to do. I have to get that data, and it costs me $8,000 a month to do it right, but I'm going to do it because it's the right thing to do. But I got to
Jim, I'm going to wrap us up here. This hour has flown by. I want to thank Jim Ganther, Max Zenon for lending their expertise, for Jennifer and Patrick and me for jumping in there with our, we had some really legitimate questions, a lot of opinions on this show. None of the panel stated a fact. It was all our opinions.
Right. That's right.
Yeah, just opinions.
We're
might
opinionated
be wrong.
bunch.
We might be wrong. I love that. But anyway, thank you for being on the show, guys. Everybody wave goodbye to the audience.
Goodbye.
Thank you.